Hello, hello, hello. This is attorney Mike Gravelin coming to you from Chicago as usual. And we had a crazy hearing yesterday. I called it Contentious Attorney in Court. And my video ran out. I wasn't trying to be bad. I wasn't intentionally naughty in this circumstance. That's just all the video I had. But thankfully, thanks to Old Squishy Gardener, I've been provided the video, so I will finish it up. It's pretty darn interesting. For those of you who weren't there, this is a woman who brought an action for a temporary protective order. She apparently has 3 attorneys. They make a horrible, horrible presentation by my way of looking at things. Pretty much all of their credibility is shot, and we carry on with the hearing today. Oh, also, I want to point out, I'll put links to him in the description below. Big Into also offered to send it to me, and I think it's up on his channel if you want to see it without me talking over it. Both Old Squishy Gardener and Biggin are completely blowing up. Go watch their videos, like, subscribe, all that stuff. They're good guys. Let's do this. Oh, I've got one more thing. You know, Judge Manning's become very popular here because, well, she's awesome. This judge I really like down in Panama City, Florida, but I don't know his name. So somebody tell me in the chat, tell me in the comments who this judge is so I can refer to him by name. I was told it was Judge Van, but I have reason to believe that that's not the case. Might be Judge Clark. I'm not sure. Tell me in the chat, please.
25,000.
That's so dumb.
I know, it's ridiculous, isn't it? It's stupid.
Yeah, copy of this $2,500. Yeah, you're going
Here, no, ma'am. You're right. It is crazy. Let's change that. Bond's 50,000.
Ms. Sullivan. I'm really upset at the fact that this is even going on. Why does this got to do with the crime?
Ms. Sullivan, answered the question. Ms. Sullivan.
I answered the question. I said, no, she wasn't my attorney. Why would I give her money?
Ms. Sullivan, she asked you a specific question about paying.
No.
Haven't paid her anything. Gotcha. Next question.
Have you paid Ms. Hood any attorney's fees for representing you today?
You can't ask me that. Why did I ask you? Have Robert paid you anything?
Oh my
Ms.
God.
Have Robert paid you anything?
Ms. Hood, get a hold of her. She's got to answer these questions because we are not going at till 5 o'clock.
Can we take a break so we can talk to her?
Can we take a break?
I'm going to object. I want her to answer my question before they take a break and go talk to her about exactly what I'm asking.
Answer the question, and then you'll take a break. Answer the question.
By the way, that objection is standard operating procedure. Before you give a deposition or anything, they say, you know, you can take a break, but you got to answer the pending question first. It's very strange to take a break mid-testimony with a witness because then you're giving the opportunity, the attorneys another opportunity to prep their client while they see the questioning. So it's not strange at all.
Question, Ms. Sullivan, what have you paid in attorney's fees? Ms. Sullivan, you will answer me.
Lily continues to have great facial expressions for this deal.
Now you muted yourself.
Yes.
What have you paid in attorney's fees?
I have paid over $2,000.
What have you paid? What is over 2,000? 50,000 is over 2,000?
I said over 2,000 I've paid into attorney's fees.
Okay, what is over 2,000? What does that mean? 3 million's over 2,000. What amount have you paid?
2,000 or more. 2,000. I'm not exact amount, but I know I've given over 2,000.
Have you paid 2,500?
Yes.
Have you paid 3,000?
No, not yet.
2,600.
Oh, thank you.
Ms. Sullivan, 2,600?
No.
Okay, 2,500. All right, go ahead, Miss Bristow. Well, I'll tell you what.
I have a question and then I'm done with my cross.
Okay, great then. Go ahead.
Ms. Sullivan, do you know that if you have attorney's invoices prepared today to present to the court that I may review?
You did what?
Do you know if you have attorney's fees invoices, like receipts, to present to the court today that I may review for what you have paid?
No. Did you ask us for that earlier?
Miss Sullivan, just answer her question.
No, I do not. No, no.
All right.
No.
I think so.
Anything else, Miss Bristow?
No.
All right. Miss Hood, any follow-up?
Just a few questions.
Okay.
Ms. Sullivan, you were asked a series of questions regarding some property that was removed from her home. You remember that?
Yes.
Okay. And you indicated earlier that you had, I guess, did an application in your TPO in reference to items that you wanted to keep in your possession. Is that correct?
Yes.
Okay. And at that time, you were unaware in reference to the standing order or whatever documentation that you had received later, because when you submitted the application, it was, shortly after April 3rd. Is that correct?
Yes.
Okay. And you also indicated earlier that there were some items that you had brought into the home when you and Mr. Sullivan decided to,
Remarry.
remarry. Is that correct?
Yes.
Okay.
Oh, good Lord. This man married her not once, but twice. There are no words.
And you also indicated that you had a son that was living in the home, correct?
Yes.
And he had some items in the house as well.
Yes.
Okay. Now, opposing counsel talked about a lot of things that was allegedly taken. But do you recall whether there were other bedrooms and bedroom suites that were inside the home?
Yes, we had a 5-bedroom house and they were all fully furnished.
Okay. And so those other bedrooms had beds in them. Is that correct?
Correct.
All right. And there was also a formal living room. Is that correct?
Correct.
I was not aware that the summer sentencing was tomorrow. That's interesting. I'll look into it.
Okay. And so at one time or another, there was, what about the kitchen furniture or what happened to that? Or was that still in the home?
The dining room set was still there. 2 living room sets. 3 bedroom sets were still there. All the appliances, everything was still there. Refrigerator, stove, oven, microwave.
And Ms. Sullivan, she also questioned you in reference to your attorney fees. You remember that?
Yes.
Okay. And at such time, you've only paid $2,500. Is that correct at this point?
Yes.
And you're aware that you're before the court on your final hearing. Is that correct?
It's a mystery.
Yes.
And that you have incurred additional expenses from your counsel in reference to pursuing this TPO at this time. Is that correct?
Yes.
And additionally, you understood that there were other proceedings prior to this date that you had incurred expenses since the $2,500 that you provided. Is that correct?
Yes.
Okay.
I'm a Lions
And
fan. I was
you were aware that there were at least 5 or 6 different recess dates pertaining to your case. Is that correct?
Yes.
Okay. You were before the court on April 22nd. Is that
by the way, the video comes back on. It's not you guys. It's frozen. Probably something I did wrong in, uploading it or whatever, but it does come back on eventually, and there's good stuff in here on the audio, so hang with it.
correct?
Yes.
And that was the first date of the hearing. Is that true?
Yes, ma'am.
Okay. And then that case was reset to May 6th. Is that correct?
Yes.
All right, and then that case was reset again until, I believe, July 1st. Is that correct?
Yes.
But prior to the July 1st date, you were before the court on May 10th as a result of Mr. Sullivan's contempt action. Is that correct?
Yes.
And you incurred additional expenses as a result of that?
Yes.
Okay. And after the May 10th, as you said earlier, there was a July 1st date.
Yes.
And that was reset to July 8th. Is that correct?
Yes, ma'am.
And there were additional expenses that you incurred as a result of your attorney being present for that day?
Yes.
Okay. And you're asking this court to enter a TPO?
Yes. Yes, ma'am.
No
Please.
further questions?
Any follow-up, Ms. Bristow?
Just a couple. Ms. Sullivan, what day did you remove your property from the marital residence?
I never got a chance to remove everything that I needed and wanted because he changed the locks.
Ms. Sullivan, what day did you remove the property?
It was
Why did you remove the bedroom suit? Are you texting with someone right now, Ms. Sullivan?
She's
No.
looking at something. Ms. Bristow,
No,
I mean, Ms.
no.
Ms. Sullivan, what day
19.
did you remove the property?
the 19th.
Oh, she's stone cold busted. She was texting.
What is it?
May 19th.
May 9th.
I mean not April.
Can I ask
Yes, I'll announce it again. The screen is frozen. It'll come back on in a little bit.
what you're looking at, Ms. Sullivan?
I'm looking at the phone, Miss Briscoe.
Okay, are you currently getting text messages from your attorneys?
No, ma'am, I'm sure not. I'm not that I'm not that equipped to be able to flip back and forth. I'm sorry that you think that, but I'm not. When I do it, I can't do that. I'm sorry.
Sullivan, stop. Next
Now,
question.
When you were removing your property from the marital residence, a police officer showed up. Is that correct?
Yes, ma'am.
And the police officer made you aware that there is a standing order in place. Is that correct?
Yes, ma'am.
Okay, so you were aware that a standing order was in place then?
And I also showed him my paperwork from the bond, where I had put at the bottom of my bond stipulations that what things that I
Might be
wanted to
right.
take.
Okay, but I just want to be clear for the court. You were aware that there was a standing order in place, correct?
Of what I wanted to take, yes.
Okay. Again, you don't have any attorney's fees invoices for me to review today for your request of attorney's fees. Is that correct?
No, ma'am.
Okay, that's all I have.
Ms. Hood.
I don't have any further questions for the witness, Your Honor.
All right. Thank you. Next witness or anything else, Ms. Hood?
No, the petitioner rests, Your Honor.
Ms. Bristow?
Yes, I'm just calling my client, Robert Sullivan.
All right. Mr. Sullivan, take yourself off mute, please, sir.
Mic check. Can you all hear me?
Yes,
Yeah.
sir.
Okay.
Now, what do you currently do for work?
Well, right now I'm disabled, but normally I would be a UPS driver / service provider.
Okay. Did you previously work for the Fulton County Sheriff's Office?
I gave the citizens of Fulton County 16 years. Sorry.
Now, do you pride yourself in abiding by the law?
Objection, Your Honor. Leading.
It was a
Please
question,
read.
it's a yes or no question.
Let's
I
say
thought I
yes.
was leading.
Okay. Move on.
Do you care about your reputation in your neighborhood?
I really do. Yes, I do.
Okay. Now, you and Ms. Sullivan, you were previously married and divorced. Is that correct?
That's correct.
Okay. When did you guys remarry?
We remarried on October 20th of year 2020.
Okay. Now, at one point during the second marriage, did Ms. Sullivan ask that her 32-year-old son move in and live in the residence with you?
Objection, Your Honor. I'm just trying to find out the relevancy of all of this.
They
I thought we were
testified
here
about
for
the son
April 3rd
earlier.
occurrence, and she's talking about something that happened previously. I'm still trying to figure out what the relevancy in reference to her questions.
Really don't understand why I'm getting objected to on relevance every single time I try to ask a question. It's absolutely relevant. This was brought up earlier. She stated that my client got in an altercation with her son, which is why she was mad and why they got in the fight, which is why we're here today. It's all relevant.
All right, I'll allow it. Go ahead.
Yeah. No kidding.
Now, back to my question. Did she request that her 32-year-old son move into the marital residence?
Yes.
Okay. How
Yes.
long did he live with you?
Right at 1 year from
Okay.
March of 2021 until March 19th of 2022.
Okay. Now, was he contributing to any of the household finances?
No, that's it. We gave $100 a month for the cable internet bill.
Mr. Sullivan, hold on. Madam Court Reporter, can you make it out? Because I know he's breaking up a little bit.
Right, not in the
Yeah.
beginning. I'm getting that too. It's almost like a delay, and then once he starts talking, I can hear him.
All right, so,
Yes,
sir, either maybe you're in the middle of the house, if you're on Wi-Fi, so you need to get close to somewhere where we can understand what you're saying.
Okay, I'm kind of sliding over a little bit. Okay, how about now? How about now?
All right, go ahead.
Okay, a question again?
I believe you just stated he lived there for about a year. Is that correct?
Lived there, yes, for a year. March, I forget the exact date, in March of 2021, but it ended on March 19th of 2022.
Okay. Now, during the time that he was living there, did you determine that he was out on bond for anything?
Objection, you got.
Yes.
What's relevant in reference to this? I'm still trying to find out the relevancy about him.
Ms. Sullivan made the
Open
court
bar.
aware that they got in their altercation because he was upset about the alter. She accused him of physically attacking her son, which is why we're here today.
No, we're not, Your Honor. She's misstating the facts. We're not here because of that. We're here because he choked her and he hit her. That's why we're here today.
Oh my gosh.
Okay. This stemmed from an event where he had allegedly gotten to something with the son. He wanted to talk about it. She didn't. So go ahead, Ms. Bristow.
Thank you. Did you determine that Ms. Sullivan's son was out on bond for any criminal history?
Yes, I did.
Can you explain that?
Yes.
Objection, you got. Again, with the relevancy.
It's the same objection we just did. She already rolled on it.
I can know my objection on a different question. I'm sorry.
That's okay.
I'm gonna know my objection on the record. Whether you like it or not, Ms. Bristow, I can object.
All right. Overruled. Answer the question, Mr. Sullivan.
Can you repeat, please? 'Cause I'm
Yes.
Oh my God. Did you know that your stepson was there or her son had criminal charges?
Thank you for the repeat. Yes, I was aware that he was there on criminal charges.
Okay.
What were those criminal charges?
A total of 6. There were 3 felony counts of possession
Objection,
of
Your Honor.
narcotics.
This is all hearsay. He doesn't know anything about it. It's almost like as if he was present.
Ms. Bristow.
Mr. Sullivan, what were those charges?
3 felony counts of possession of narcotics, and 3 felony counts of child pornography.
Okay. Was this concerning for you with him living in your house?
Yes.
Now, did this ultimately lead to you and Miss Sullivan's son getting into an altercation?
Yes.
Can you explain that?
Well, I started noticing changes in behavior with both parties, both my estranged wife and her son. I started asking questions about his behavior. I started asking light questions about status of his case. Initially, when he first moved, I wanted to make sure.
I'm sorry, Mr. Sullivan. You're breaking up again
Yes.
in the middle. If you can say,
Okay.
I started asking, did you say night questions?
Light. I said light questions, like
Thank
making
you.
kind of light inquiries about when is it? It's been a year now. It's going up on a year. Has he heard anything from the courts back in Texas how, I noticed some changes in his behavior. He becoming more standoffish. I don't know if it was because he was worried or if it was because of other reasons, but I started asking questions about his being there because I started seeing change in both people.
Okay, did you get in a physical altercation with him?
Yes, on March 19th, initially the three of us were supposed to sit down as a family unit
More t-shirts.
and discuss the living conditions there. So if you're going to be here for an elongated period of time, number one, I want to make sure you're okay. And I was just about getting on the brink of going back to work. I was out for like 9 months with knee replacement surgery and the torn up quadricep muscle that still hadn't fully healed from.
Yeah, Mr. Sullivan.
Okay, so I was going to ask him, we're going to talk about his being there, and you're going to have to start contributing if you plan on being here for an elongated period of time. That turned into animosity, and that culminated in her son bursting out of the room at me while we're sitting upstairs in the loft area over a conversation that his mother and I were having. It wasn't a vicious conversation, and using profanity. He was wide-eyed, sweating profusely, slamming his hand up against the wall.
Order that she attempted to file in 2018.
What they all are.
Okay, so you don't really know what type of medication that could.
You're breaking up. One more time.
And you can't speak about any type of mental health condition. Okay. Now you indicated earlier when your counsel asked you a question that, and I think you responded that you pride on abiding by the law. You remember that?
Yes.
Okay. And you recall that you were before this court on a contempt.
Yes.
Okay. And that contempt was based upon violations of an order. Is that correct?
That is correct.
All right. And you also can agree that there was an ex parte order indicating to stay away from the home. Is that correct?
That is correct as well.
And you violated that on numerous occasions. Isn't that correct?
I was incorrect for that.
Okay.
I had the police with me. And I just misconstrued my position. I'll just put it that way.
Now, in the special condition of the bond, you were only allowed to come there once. Is that correct?
This is what it read, yes.
Okay. And you came there more than once, whether it was an officer, whether it was a neighbor, or whether it was friends. Is that correct?
With officers is correct, yes.
Okay. And you spoke about a temporary protective order that was dismissed some time ago in reference to you and Mrs. Sullivan. Is that correct?
That's correct.
All right. And you have been accused for violent behavior in reference to a previous marriage that you were involved in, where a TPO was involved. Is that correct?
That's correct.
Okay. And is it also true that on April 3rd, you were upset in reference to what had transpired between you and the son?
No, I wasn't upset because of that. That was a done deal.
Okay. So when you say it was a done deal, you wouldn't have brought it up on April 3rd on the day of the incident, correct?
No, I wouldn't have brought it up, but there was an exchange regarding that subject matter that I didn't bring up. I was a part of an argument, and the petitioner brought it up. I didn't bring it up, but I did participate. Okay, so you're saying that you just only participated
This guy just comes across as reasonable. I'm sorry.
and you didn't bring it up at all, at no time.
I did not initiate, but I was involved.
Mr. Sullivan, yes or no? Yes or no? Yes or no? And then you can offer an explanation.
I thought I did say yes. I thought I did say yes. Yes.
Okay.
I was involved in an argument.
I'm sorry, you finished?
Yeah.
So on April 3rd, you got mad at Miss Sullivan and you took a broomstick and you hit her, didn't you?
No, I did not.
Now, Mr. Sullivan, you heard the testimony of the officer. Is that correct?
I did hear the testimony of the officer.
Okay. And he indicated that he saw the broomstick.
He indicated that he saw a broomstick. I never saw a broomstick to this day.
Okay. And you also heard from the officer
He also indicated that he didn't see him do anything.
that he saw that broomstick that was bent.
Just saying.
He described the broomstick being bent.
He described a broomstick
Yes or no?
that was bent, but again, I never saw that. Yeah, the answer is yes.
Yes or no? Then an
I said
explanation.
yes.
And he also described that there was an injury on Mrs. Sullivan as a result of that broomstick, didn't he?
Yes.
Okay. And as a result of that, you were arrested. Isn't that correct?
That is correct.
Now, you indicated that there was a disturbance that was described involving Miss Sullivan regarding a boot. You remember that when you talked to your counsel in reference to this boot that she had on?
Yes.
Isn't it true that you got angry at her and you stomped your foot on that boot?
That is not true.
Isn't it also true that you began yelling and slurring and wanted to hurt her on that time and threaten her on that day? Isn't that correct?
That is incorrect. That is not true.
Now, going back to March 19th, you don't have any video in reference to this dispute between the son and Miss Sullivan on March 19th. Is that correct?
Agreed. I cut that part out, but yeah.
But you described that you guys had you guys were discussing this argument in front of the house. You were on the porch. Isn't that correct? Where the ring video is located.
Now, are you referring to April 3rd or March 19th?
No, I'm speaking about March 19th.
No,
Yeah,
no,
that's
this incident occurred in the home upstairs in the loft area that we had set up there.
Okay.
He came out of the bedroom that he was sleeping in. He just he went off.
Okay, but in reference to April 3rd, you described that you guys were sitting outside on the front porch. Is that correct?
Well, I was sitting on the front porch. The petitioner never sat down.
Okay, so the petitioner never stepped outside and leaned on any type of object while you guys were outside.
She leaned up against the house.
Okay. And you testified today about some numerous incidents involving Miss Sullivan, but you don't have any eyewitness to that. Is that correct?
That is correct as well.
You never called the police.
Never called the police.
And you don't have any photographs or videos in reference to any injuries that you may have had as a result of this occurrence. Is that correct?
In the past, well, I did share a fuzzy video from the knife incident with my attorney, but we decided not to use it. I still have a copy of it in my phone right now. But other than that, nothing that I really made a big deal out of.
But you don't have anything today, is that correct? So you have no proof in reference to these numerous incidents, is that correct?
Well, I still have the video in this phone. So, but for court purposes, I would say that's correct. But if I'm pressed to use it, I can.
Now, Mr. Sullivan, isn't it true that you're under medication for mental health?
No, that's not true.
So you never was prescribed any medication for any type of mental health condition. Is that what you're telling the court?
That is what I'm saying.
Now, isn't it true that the neighbor next door who you said actually installed the ring video is a good friend of yours? Isn't that correct?
Yes.
Okay. And isn't it true that it was from your direction that your good friend took that documentation regarding this ex parte order that this court put in place down for his friend? Isn't that correct?
That was not correct. I had no idea that he did this.
So isn't it true, Mr. Sullivan, that you actually called on April 9th to gain access to that house? Then you call to try to go to the house again?
No, I did not. April 9th?
April 9th.
I don't recall the dates. All I know is I did go there committedly and obviously on more than one occasion with the police.
Okay, but you knew that you weren't supposed to go in the house, period, whether it was with the police or otherwise. Correct?
I didn't
I
know
believe
that.
all
I
of
didn't
this
know
was
that.
asked and answered at the beginning.
I'm speaking about April 9th.
No.
And isn't it also true on April 25th, Mr. Sullivan, that you came to the home with your realtor?
That is incorrect.
So you're saying that you never entered in the home on about April 25th?
No, I did not. The real estate agent went on his own. Never even hadn't physically even met him yet. I did call ahead. It was on a Saturday. I called ahead to the South Fulton police to try to see if I could get an escort. And they said that they could not escort. So I ordered a meeting with the realtor. And at this time, the petitioner had moved out of the house. So
I'm going to show you what has already been admitted to evidence, Mr. Sullivan, which is a ring video with you and your realtor, Charles Sullivan, entering into the home. And that's Exhibit 8C.
We did enter the home, but it wasn't the 25th because I remember the first time he ever showed up there, that was on a Saturday. Now, if you have any footage of him, he and I and two police officers from South Fulton entering the home, that was during a weekday. I don't know the specific date. If I had to really remember correctly, I try to be as vivid as I can with my memory. But if I'm not mistaken, I think that was somewhere around the 27th of April. It was doing, and I know it was during the weekday. It wasn't on a weekend.
But you do identify that you were there and you weren't supposed to be there. Is that correct?
Well, I wasn't really sure if I wasn't supposed to not be there if the petitioner wasn't there. That was a question that the police and I had, the sheriff's office and I had, and everything seemed to be safe. So
now, Mr. Sullivan, you were aware that there was an ex parte order saying staying away from the home. Is that correct? On April 27th.
I had a bond condition that said that, but the ex parte documentation didn't specify that. And the question was, which one supersedes the other? And
so you're saying that you just didn't read your ex parte? I'm just trying to figure out why you feel as though that you weren't supposed to come to the property.
You can't talk over one another. Let her finish, ask her the question, then you can answer.
Correct.
Go ahead.
Oh, I'm sorry. So, Mr. Sullivan, so you're indicating that this ex parte order wasn't in existence. I'm just trying to figure out, in reference to your explanation as to going on to the property since you're an abiding citizen.
Right. So, no, I'm not disputing its existence. Just reading it, it's specified that I could go by there with police or sheriff. And the question that I had was, which one supersedes the other, the ex parte or the bond conditions? I asked that question with the state court level. And from what I gathered after all of this is that the bond condition supersedes the ex parte. I don't know how correct that is, but I was awakened by the circumstances of it all. And I'm thankful for that. And I realized the errors in that regard.
Now, Mr. Sullivan, you were aware that both the ex parte order as well as the special condition bond told you to stay away from that property?
I was aware of both. I think I answered that, yes.
Okay. And the special condition only allowed you to go one time, and you're indicating that you went there besides the one time.
Yes, that's.
I'm sorry, I have to object. This is being asked over and over again. It's already been answered.
I've got it.
I can follow up on the questions in reference to this witness.
Okay, so
basically said he was just doing it because he wasn't understanding what the ex parte order was.
Ms. Hood, he said I got it. He went back. If you want to ask him what he did on that date, that's fine. But please stop rehashing that he went back. We had a contempt hearing on this. I think he went back 4, maybe 5 times.
No further questions, Your Honor.
Any follow-up, Ms. Bristow?
Yes, like 3 questions. Mr.
Did you say
Sullivan
quite a few, or did you say a few?
said 3.
Okay, I was about to say, okay, go ahead.
Not quite a few, I promise. Mr. Sullivan, was it your understanding that both the ex parte order and the TPO was put in place for Miss Sullivan's safety?
I'm all
was
for
I
it.
aware of
I
it?
don't know her.
If
Yes.
I
Is it
break
your
my-
understanding that you were told to not be around Miss Sullivan for her safety in the ex parte and the bond conditions?
Yes.
Okay.
Yes.
And so when you were returning to the home, was it your belief that it was okay because Miss Sullivan had actually moved out?
Yes, that was my belief. Yes.
Okay, but you were obviously corrected on that by Judge Manning at the contempt hearing, correct?
Absolutely, I was. Yes.
Okay, that's all, Judge.
He's actually likable. Okay, so there was a contempt hearing. He got thrown in jail for going back and violating the bond condition. He doesn't even fight it. He's like, I don't know. I was trying to do this and that. He gives his explanation. He loses on it. He accepts it. He carries on. I don't know. And I thought all of his testimony made sense and seemed credible. I really did.
Pretty sure he went to jail. Go ahead, Ms. Hood. Anything else?
No other questions, Your Honor.
Okay,
All
someone
right.
knows her.
Anything else, Ms. Bristow?
Hook us up. I'll have her on.
All right. Closing, Ms. Hood?
Thank you, Your Honor. Your Honor, this is a case involving abuse, repeated abuse. And I want the court to just focus on the main issue, that there was an occurrence that took place on April 3rd of 2022. We heard from the officer, Your Honor, in reference to what transpired. We heard from Officer McClain. And Officer McClain testified that he has investigated numerous of domestic violence cases, that on that day he was called to that actual location. He indicated that he spoke with Ms. Sullivan in reference to it. He testified that she indicated that Mr. Sullivan hit her with the broomstick. He choked her. He slapped her. And he also indicated as an officer.
No, he didn't. This is absolutely mischaracterizing the testimony. I watched it. He said I didn't observe anything, and that's the story the victim told me, the alleged victim. That's what he testified to. This right here is I don't think it's proper.
You know, they do a report and they make a record of any observations or impressions. He indicated that he saw a visible bruise and took a photograph of that, Your Honor. He also indicated that he also saw a broomstick, and he saw a broomstick that was bent. Now, Mr. Sullivan wants the court to allege that nothing happened on that day. But it's clear that something took place and that there was some physical altercation on that day. We heard from Ms. Sullivan in reference to April 3rd, Your Honor. And Ms. Sullivan again indicated, just as the officer indicated, that there was a dispute, that she didn't want to continue to argue with Mr. Sullivan. So she did the right thing. She walked away, went upstairs, hoping things that were going to cool down. But it didn't stop there. Mr. Sullivan continued to harass her, continued to press on. He came upstairs. He had that broomstick, Your Honor, as Ms. Sullivan testified. And
okay, it's official. Lily Bristow, you are now formally invited to come on Law Talk with Mike and laugh at some clips that you're not involved with.
He took it along her chest and put his body to her knee, Your Honor, choking her. Ms. Sullivan said she had to kick her leg up to move her knee up just to get out of that situation. She first thought it was a clear, Your Honor, to be able to get out of the situation, because she said she was in the foyer and she thought he wasn't there, Your Honor, as she testified. But he was there, and he took the broomstick and he started swinging it and hitting it again, Your Honor, causing her to fall down the steps. Ms. Sullivan testified that she had to actually crawl out of there, Your Honor. She testified that she immediately contacted the police and had someone to come over there. We have a series of exhibits that were omitted and tendered. As the court can recall, on May the 6th, there was a 911 audio call that was taking place, which was Exhibit 1A, in which on that 911 audio call, she basically explains to the dispatcher, advising that she's being abused by her husband, that he dragged her, he choked her, he slapped her. We also have the incident report on that, Your Honor. In addition to that, Your Honor, that Mr. Sullivan was arrested. The officer felt as though that there was sufficient evidence or cause to believe that there was a simple battery, or excuse me, family violence battery that did occur. So he arrested him on that day. And what did Mr. Sullivan do after he had the special conditions of bond? He abused it. He abused it, Your Honor. He continually harassed Miss Sullivan throughout that time period. He not only
Oh, she's just so sleazy. I mean, I hate to say it. At least that's the way it's coming across to me. She tries to say, oh, he abused the conditions to make him an abuser. I mean, it's very simplistic or whatever. But I'll tell you what, I don't know. I'm not the finder of fact on this, but I do see some questions in the chat about it. Yes, there's a divorce going on. I think that this whole thing is drummed up to manipulate the divorce proceedings. That's what I feel like. I don't know that I'm right. I'm not close to the situation. I've only seen this hearing, but that is the overwhelming vibe I get from watching Miss Sullivan and her legal team. Sorry.
Only came back to the house on April 4th when a special condition of bond, as the court knows, that was tendered as Exhibit 11 that specifically says one time. It didn't say 2 times. It didn't say 3 times with the law enforcement officer. It didn't say the 5th time with another officer. It said 1 time to get your belongings. And what did he do? He abused it. As the court is aware that there was a call, 911 audio call on April 5th, Mr. Sullivan coming back onto the property again. Ms. Sullivan testified that he came back twice. Not only with the officer, he came back with some clothes and threw it down to her. Then there was another incident, April 6th, an exhibit that was tendered 4A regarding Ms. Tanya Sullivan calling 911, saying that Mr. Sullivan is back at the house again. Back at the house again, when he knew that he was supposed to stay away from Ms. Sullivan with the special condition of the bond. Not only did he come back on April 6th, Your Honor, he came back on April the 22nd, and he also came back on April the 25th. And as Your Honor, you are fairly know that we came back before this court on a contempt because he changed the locks, because he didn't want to listen to the court's order, this court's order. So it shows a pattern of his behavior. It shows a pattern of him harassing her and manipulating the system to get what he wants, Your Honor, and to remove my client from this home. The court found him in contempt as a result of his repeated violations, Your Honor. And the defense wants you to
Manipulating is a crime in 3 states.
to just put that aside, Your Honor, and not focus on the real issue. And the real issue is here. He is abusive. And he has been abusive with Ms. Sullivan for a long time. Ms. Sullivan talked about some subsequent incidents that happened in 2012. She talked about how he pulled a gun on her. He put it to her head out in Alpharetta and Roswell, Your Honor. And if she didn't have her head in that area, she would not have been here today. She also talked about another occurrence that happened in 2017 where he took a boot, where she had a boot and he just took his foot and slammed it. Mr. Sullivan wants you to believe that it's everybody else's fault but his own. That the reason why we're here, Your Honor, is because of Mr. Sullivan's violent acts, Your Honor, because he continuously has been abusing Miss Sullivan repeatedly. He then has a friend, his neighbor, who actually installed the ring to take down the orders that Miss Sullivan was provided by this court and given instructions by this honorable court to post these things and to make other law enforcement and other people that come to this house that he is not to be there. And once again, Mr. Sullivan wants to manipulate the system. He wants to say, oh, well, I really didn't understand. Oh, well, there were two different orders. I don't know which one to believe. I don't know which one I should. Well, it's just so confusing. But what's not confusing is that both of them said, stay away. Stay away. Stay away from her. Ms. Sullivan has indicated on numerous occasions during her testimony that she is scared of this man, that she is frightened with him. In fact, the officer said that she was visibly shaken. He actually testified that, you know, he gave her those special instructions to apply because she was afraid of her safety. And so I'm asking, Your Honor, that you put in place this temporary protective order to protect Ms. Sullivan from this person, Mr. Sullivan, who has been repeatedly violating the order regarding her safety. I'm also asking the court to award attorney fees.
Yes.
Ms. Sullivan has indicated that she's already paid $2,500. She's indicated that this hearing has not been completed, Your Honor. She also indicated that there were numerous court appearances. She talked about how the cases was reset from April 22nd, that we had 4 or 5 different reset dates in reference to it. She's indicated that there's going to be some other monies that she's going to have to pay. And she would not be here but for Mr. Sullivan's actions, Your Honor. Thank you.
Ms. Bristow.
Yes, Judge. I believe the evidence presented today by Ms. Sullivan does not meet the threshold necessary to extend this temporary protective order against my client. Ms. Sullivan has no real fear for her safety, and she did not present any evidence today to show that there is any present risk of harm. She's currently not even living in this state. She refused to answer the question, and my understanding that the court can infer negatively against her refusal to respond. In the event this TPO is granted, it could have serious consequences for my client's job. Mr. Sullivan cannot afford to lose his job, especially now that he's already lost his home. Mr. Sullivan wants nothing more than to keep his distance from Ms. Sullivan and move on with his life. Ms. Sullivan is now living elsewhere, and the parties have no reason to come in contact with one another. Mr. Sullivan is already dealing with pending charges against him due to Ms. Sullivan's false allegations. Furthermore, the bond conditions that came with those charges already protect Ms. Sullivan. There's no need for an added temporary protective order when Ms. Sullivan already has the protection she's asking for here today. The only reason for this hearing is to further cause anguish to Mr. Sullivan and to hurt him for wanting another divorce from her.
Yep.
I think it's very important that this court considers the way these two parties conducted themselves in this hearing. The difference in behaviors here today should really say a lot about credibility. I could not even get through simple questions with Ms. Sullivan today without her getting visibly angry and arguing with not only myself, but with this court. She lied to this court during this entire litigation about whether she lived in the home, and she continued to lie about the same thing here today. Should certainly go against her character and credibility, in my opinion. Now, in terms of their request for attorney's fees, I have not seen a single invoice for their attorney's fees. It's my understanding that these would be required and that my client should have the ability to review and pose any questions against those attorney's fees invoices prior to a ruling on same. They didn't show up with that today. That's on them. That said, in terms of attorney's fees request, I would ask that this be denied. Furthermore, I would ask that the temporary protective order be dismissed.
All right. So let me get a couple things. The court reporter here, what the officer said was there were 2 calls. There were 3 calls. 2 calls. The first 2 calls were so she could get an escort by the cops to pick up her belongings. Third call was the one where she made allegations of family violence. Okay. The incidences previously were heard by 2017 and 2012 or 13 were heard by Judge Houston, and she found that she didn't meet her burden. So that TPO was set aside. Okay. Now, part of a TPO is, one, that family violence has occurred. Secondly, that it's going to occur. There's a reasonable likelihood that it's going to occur in the future. Now, Mr. Sullivan, I threw you in jail for contempt. And I made it clear. Don't go means don't go. All right? So I was pulling up the case here because I had to get a good timeline because you guys were kind of all over the place. All right? So,
thank you, Mindy.
On April 18th, she was served with a divorce. April the 6th, she filed for the TPO. He wasn't served with a TPO until May the 6th, where he acknowledged in open court.
No, Your Honor. April 22nd is when he received it in open court.
It's dated May 6th.
Yeah, but he appeared during the April 22nd hearing, Mr. Sullivan did, without his counsel. And basically in open court, there was I can't remember the judge's name, and she advised him of the standing order, told him that to stay away from it, and then she got his email address and emailed it to him.
Okay, once again, in the court record, it's dated May the 6th. All right, I have to go by the court record. Now, yes, he was arrested. You got a burden for probable cause and a burden for preponderance of the evidence. The definition of probable cause is that which would lead a reasonable and prudent person to believe a crime has been committed, is being committed, or is about to be committed. It is more than mere suspicion, but less than absolute certainty. That is Black's Dictionary's definition of probable cause. The burden here is a preponderance of the evidence, more likely than not, which is a higher burden than probable cause. So, I didn't see a whole bunch of proof of anything with bruising on the neck. She shows this bruise on her leg. No bruising around the neck. If she were choked, if he used the broomstick to choke her, there was none of that. I mean, I didn't see. There was the one picture of the bruise on the leg. Now, I'm sure that police officer has investigated a lot, or at least taken police reports on a lot of investigated domestic violence actions, okay? And he writes down reports as to what people say. So, with that being said, nobody has modified, Mr. Sullivan, your bond conditions. I see that it's still just out there pending in Judge Morrison's courtroom. You have the accusation, and that's it. I don't see a plea date. I don't see any sort of scheduling or anything in Judge Morrison's courtroom. And if I got that wrong, let me know. But yeah, I don't see anything in Judge Morrison's courtroom that's scheduled for that. So she did. She wouldn't say whether or not she lived in Georgia. Obviously, probably she doesn't, but she did not. She refused to answer that. The house is sold. That was a big thing. He doesn't know where she lives. There are still bond conditions. There has to be a reasonable likelihood that violence will occur in the future. I don't see that. He has no idea where she is at. Mr. Sullivan, this does not relieve you of your bond conditions. Your bond conditions, sir, say no contact. But your bond conditions also said you could go over once with law enforcement. You went over there more than once. That's why you went to jail. That's why I put you in jail. So I would tell everybody, I really try to be patient and let people get their say. I'm telling council parties, everybody here, y'all need to get it together. Act better towards the bench and one another. This is a hard profession, period. Your behavior is completely unacceptable. Completely unacceptable. And I have had it up to here with people doing that. And it's not just y'all. For some reason, lawyers have lost their minds. And I hear more cases every week than any judge sitting on the bench in Fulton County. I can promise you that because I do bond hearings at night and I do counters all day. So, I guess Ms. King that would hear me much. So, no, I am denying this. I'm also denying the attorney's fees because there should have been something mailed for attorney's fees, some sort of testimony, some sort of bill. And Ms. Sullivan doesn't have too much credibility when it came to the attorney's fees because she kept sitting silent. So like she was doing math or something in her head and she didn't know what she needed to do or what she needed to say. So I'm denying this on failure to prove. I'm also denying the attorney's fees. Ms. Bristow, would you like to, and I'm just telling you, there is nothing else here. It's the bond conditions, Mr. Sullivan. Like I said before, you have to modify those bond conditions.
Yes, ma'am, Your Honor. I was just waiting until this hearing
Ms. Sullivan,
adjudicated.
this is what I'm talking about.
Okay,
Here.
sorry. I know you're giving me a form to speak.
I don't want to hear. Ms. Bristow, you can send me an order. I'm just giving you both fair warning that there is a standing order in place. You both are a part of that standing order. Heaven help both of y'all if y'all go in front of Judge Ellerby and somebody's gotten rid of stuff and did away with marital property or anything like that, because that's exactly what the standing order is in place for, that you should not do that. My money, your money, our money. I don't know. Some married couples have individual accounts. Some have joint accounts. Doesn't matter. If I buy something at this house right now, it's mine and my wife's. It's not just mine. The only thing that's probably mine is my clothes. She would want to name my clothes. But anyway, that's it. So I'm just cautioning you not to get rid of anything. Now, Mr. Sullivan, although this isn't in place, once again, I'm going to hammer this home. You can't have any contact with her. They can revoke your bond, sir. And I don't think you liked it when I put you in jail. So, everybody, y'all put your emails in the chat. Thank you, Madam Court Reporter. I hope you got a good record, although everybody was talking over one another, disconnecting, reconnecting, bad connection. I hope that you do. I hope that everyone has a good weekend. Everybody stays healthy and safe. Put your emails in the chat for Miss Free. Miss Free is sick. She's going to go home. Have a great weekend. She shouldn't have anything with me the first couple days this week because of Yom Kippur. So hopefully she'll get some rest and feel better. Put your emails in the chat quickly and leave so that Miss Free can go home for the weekend. Everyone, take care.
Well, there you have it. There you have it. That's the rest of the hearing. Thanks again to Old Squishy Gardner. Thanks again to Biggin for offering to send it to me. I thought that was very interesting. I saw it in the chat, so I knew what the one ruling was, but it was also good that she denied attorney's fees. I thought Judge Manning did a fantastic job in terms of her ruling and putting up with all that stuff. She kind of yelled at the attorney. I definitely think that both two of the three attorneys, the guy never said anything. Two of the three attorneys for the petitioner, along with the petitioner, I think they all, their behavior was sufficient to justify contempt if you wanted to do it. The judge didn't want to do that. Ruling against them, she thought was sufficient. I think she came to the right decision for the right reasons, laid out her basis very clearly, and we go from there. Those attorneys, I don't know the whole story, but like I said, I got the overwhelming vibe that they're trying to manipulate a divorce and run up attorney's fees. And yeah, I don't know if the judge went that far, but she seemed to be in that same ballpark. I don't want to speak for her. That's the vibe that I got from this. I thought that whole thing was kind of, that whole petition was frankly creepy. That's what I got of it. Now, I wasn't there. I wasn't there for that. I'm not excusing domestic violence or anything of the sort. I'm saying I don't believe her. It's all based upon her word, and her word is not good based upon the testimony that I saw over a 2.5 hour hearing. By the way, it was 2.5 hours. She said it will not go over 2 hours. It was 2.5 hours. And yes, we love Judge Alex Manning, and she's right. There's two things. I said this on another video. She's got like the worst calls. She's got these TPOs and all this family law stuff, and then she goes and like does pre-trials with the felons on these ginormous calls. She is a hard worker, but it's interesting stuff to watch. That hearing was kind of funny, but it was also just really interesting. There was lots of good drama, and I enjoyed it all. So thank you all for coming out. I will see you all soon.